the area of the 1911 contracts, and those parcels feed into those.
Group B?
Group B will concur with the statements made by Ms. Saletta, as well as her framing of the issues.
Yeah, the comments with respect to the drainage-only parcels and the petition that we submitted, that's exactly right. And there really is no purpose for that, for those parties being in this proceeding. And I would hope that that might be something that we could get determined maybe even today, given there is some concurrence along those lines. So I'm hopeful that that's at least one issue we might be able to knock off.
Yes, we addressed the question of the drainage-only customers in our papers because we had some questions about what exactly was meant by that and who these customers were. We do not have a problem with excluding pure drainage-only customers who would not have rights impacted by a CDO if one were to stay issued against Woods. And based on the additional information provided by Ms. Spalletta today, that the drainage-only customers are talking about have different lands. They don't relate to the Woods system at all. They're not within the area of the 1911 contracts, and then we would support the position taken by the prosecution team that they don't need to participate.
Valerie?
I think on the larger question of scope and not to the drainage issues. Again, my comments on this are based in kind of practical parlance and not specific code. But my question on the scope is I'm wondering what that end CDO would look like. And it's really hard for me to figure out what we're doing. Are we starting with 77.7? Are we starting with just the record of information and taking that number off the table? Is this just a reopener to allow landowners come in and prove upwards of that right? And what exactly that CDO looks like if it's not a definition of right? Is it a, we think the Woods Company has its own right of X and the landowners have their right of probably about this much? I guess from my perspective, the scope just leads me to ask more questions about what our end product or our end goal coming out of this hearing is. And I understand the scope as it's written, but to be honest, it provides me more questions rather than clarification at this point. So I don't know if we were going to go through that later or if we want to go through this without a specific determination or end goal in mind. But I guess with this scope and having the landowners come in and prove stuff up, I'm trying to understand what that end order would look like, and I just don't know what you guys have in mind. So if you have any thoughts on that, that'd be, I think, helpful from my perspective in further defining the scope.
Thank you.
And I'm sorry, if I may, and I appreciate that, I didn't address the scope question just yet. We do agree with Ms. Spalletta that the two key issues should be flip-flopped. And then we've set forth in our papers that we think the original terms of the order do need to be modified to the extent that it's starting at 77.7 CFS. But beyond that, the record would be supplemented as we've talked about, and then we concur with the questions that Ms. Kincaid has asked.
Great. Stanley?
Yeah, I concur with those comments.
Prosecution team?
Thank you. Just a couple of thoughts. We already weighed in with our agreement that drainage-only customers don't need to be parties to this, and as it's being described, I think we're in full agreement that anybody who receives water, anybody who doesn't receive water through Woods facilities does not need to be a party to this. Our perspective in, we were trying to figure out exactly what was meant by drainage customers, but I think the way that it's been phrased satisfies our concerns that if the prosecution team or another prosecution team brings another proceeding against somebody outside of the Woods service area, that they're making a statement here, or that there's some stipulation here that everybody who is going to claim water under Woods's rights or through Woods's facilities is a party to this hearing, and anybody who is not a party to this proceeding is not going to claim that later. So if somebody on the other side of a river wants to all of a sudden say, well, we get water from Woods too, I think what we would hope for from this decision as to the scope of the hearing would be that there's some sort of definitive either stipulation or decision by the board that we're dealing with everybody appropriately here. You can't stop somebody from claiming it later, but if there's a stipulation that this is everybody, then that will make issues in any other cases that might come up much easier. So I do want, our goal is that we agree that only the universe, the appropriate universe should be included here, but also that all of it is. The other comments I wanted to raise as to the scope of the proceeding, there's been some confusion as to how terms are being used, and I think that people are using the term order differently here as to how the order should be revised. Our perspective is that the somewhat largely in line with Water Rights Order 2012-0012, in that I think our perspective is that the board had adequate information in front of it to make the legal and factual conclusions from the 10,000-foot range as to things like delta pool theory and potential riparian rights as to these parcels and these other things. And so we completely agree that the cease and desist ordering portions of Order Water Rights WR 2011-0005 may very well change and should be subject to change based on evidence that's presented here. But I think that evidence would supplement and not rehash the 10,000-foot questions or the questions specific to Woods Irrigation Company that have already been determined. I think that the board should definitely consider if parcel-specific information may require revisiting those, but our assumption is that most of the information and evidence that will be presented will be specific to parcels and not as to the whole area. And so our hope is that those larger questions don't need to be rehashed here. So when different people are talking about what part of the order should be changed, our hope is that the ordering portion of the order, the portions that were struck or specifically intended not to apply, as stated in Order 2012-0012, be the parts that are most obviously open for complete overhaul if necessary, and the rest of it be tweaked if evidence supports that.
David, and what I'm doing here is kind of going off script because some very important issues have been raised about scope, and we really have got to get this one right to make it sane for all of us. Because reading all the existing work is going to be challenging, and we're looking forward to it, but challenging. What do you think about the flip-flopping the questions?
I think that makes sense. I mean, I think the board may have been, I don't know, I think the board may have been looking at it from a how did we get here perspective, and I think Jennifer may be looking at it from a how do we get to the next here perspective. I think if you're answering both questions, the order of them isn't crucial one way or the other. I wasn't relying on one going before two, but I think it makes sense that the evidence question come before the what to do with the evidence question.
But you did suggest that you, rather than making a decision as to whether the draft CDO would issue or would would be amending a prior order, you were favoring the amendment of a prior order rather than focusing on issuing a CDO per se. Is that, am I hearing you correctly, or?
I don't have a strong opinion on what the mechanism is. I'm merely reflecting how I understand Order 2012-0012, which struck or stayed or did not implement the ordering portions of Order 2011-0005. I think that all of the text, the 60 some odd pages that were written, still have validity as part of the record, and I think that those should be part of a new order. Whether that new order is amended 2011-0005 or has a new 2015 number, I don't have a strong opinion on that. I think that those are necessarily going to be part of the record and necessarily should be part of the order, because even if the board can't reach final determinations on the factuality of each landowner's right, I think that the legal discussions that have already been up to the Court of Appeal and back, that, again, from that 10,000 foot level, certainly do have relevance and would provide at least the prosecution team, if not other water right holders and the board in the future, some direction as to how it looks at some of those larger issues. So I think they're relevant. I just don't have a strong opinion as to whether the mechanism is amended or not. And if there's any evidence that necessitates amending the ordering portions, then we're fully in favor of that.
Vice Chair, may I respond to that, please?
And in fact, feel free for all of you to respond, because I think this is the crux of today.
I actually think it's the crux of today, too. And this is an issue where I think that Ms. Kincaid and Ms. Diepenbrock and I are in agreement, and possibly not in agreement with Mr. Rose, and I'll explain why. Ms. Kincaid and Ms. Diepenbrock said, you know, they have a concern with the state board starting with 77 and seeing if it can add to it. You know, on the one hand, I'm tempted to say, yeah, go for it, because I think you're going to get higher. But the constitutionalist in me says they're right, okay? And I also feel very confident in the evidence that we're going to put on, that you're going to be able to review the evidence from both hearings in its entirety and reach a decision that's 77 or higher. So I have no problem with the state board starting from scratch. I also believe that it's proper, because you should be making a decision based on the totality of the evidence and the arguments in front of you, and not relying on a predetermination as a starting point. There's also a legal issue here, and it's one where it gets a little esoteric, but I think it could actually become very important if there's ultimately an appeal of your decision. The San Joaquin County Superior Court set aside this entire order as void for two reasons: due process and lack of jurisdiction. The Court of Appeal only reversed on the lack of jurisdiction issue, not on the due process issue. We have technically now have an order that has been declared void by the Superior Court. So for this board to now take a void order and use it as a starting point for your decision, I think raises some serious problems. If you're going to be looking, and the state board may disagree with me, but that, of course, you know, is an argument I have. It's an argument that can go in the trash can if you agree that you're not going to use it as a starting point, if you agree that you are going to look at the evidence as a whole and issue a new decision. It would make me more comfortable. I think legally it would be more defensible. There is also an issue I should talk about, which Mr. Rose touched on, which was this whole Delta Pool concept. It relates only to the riparian rights, okay? As I explained before, it's very possible the state board could reach a decision and issue a CDO without ever having to reach the riparian right issues. And frankly, I think it would make everything a lot cleaner and less foddy for appeal. So I would like to see that happen because I don't think that the Delta Pool arguments in the prior order should be precedential. I think, frankly, they're not because the trial court declared the order void, and it just avoids a big hornet's nest. So for those reasons, I would really encourage the state board to start fresh with its order. You may end up landing in the same place on certain issues, but if you have started fresh and reviewed all the evidence and then issued a decision, I think it's much more defensible.
Can I ask a question about that or follow up?
Let's have Mariana weigh in, and then you'll be next.
So I wanted to just say a few words about what we did in my understanding of what the board did in 2012-12. So it voided the CDO and said the rest of the decision is not precedential. So we already have not precedential for everything. You're correct that I disagree about the mootness and the voiding and whatnot at the trial court level. I also agree that's not sort of the crux of the matter. I mean, if you want to brief the issue and have us deal with it, I think we could, but I don't think we need to move forward at this point, and I don't know what it would really bring us. The order as it remains is an analysis of the evidence before the board. If we are not given new evidence, I don't think that there's a reason to change what's there. New evidence, new legal arguments could also come. So new evidence and new legal arguments are the things that we can get from new parties. We have opened this up to some specific new parties. All of that is subject to change. None of that is an expression of the board's understanding in 2012 of the evidence that was presented in a 2010 hearing, which is the evidence that Woods presented, that Modesto Irrigation District presented, that the San Luis Delta Mendota Water Authority presented, and that the state water contractors presented, and that the prosecution team presented. Some parts of the order addressing, these arguments about our authority, for example. I mean, there have been a lot of changes there. I don't think any order that's written in 2015, hopefully, will, obviously that's gonna be changed. What's there? There's the full expectation that is open to change. I think there is a lot of discussion of the evidence that was presented in that order. I can only imagine that it would be helpful for parties to see how the board looked at that evidence. But that's not to say that every single thing in there, including the 10,000-foot arguments and arguments about Delta Pool and who's a riparian, those are still on the table unless you guys reach some kind of stipulation. Every decision that we made in there that was necessary to the outcome is on the table. And with other legal argument, with other evidence, the board could easily reach a different decision. And phrasing the hearing issues, I think, has confused people about, this isn't a hearing about here's what we're going to do, should we tweak it? It's a decision about, are we going to issue a CDO? And if we do, is this order going to look the same? Is it going to look the same as Order 2010-05, or is it going to look like something different? That's sort of where my understanding of where we're coming from at this point. And I hope that can sort of move the conversation forward.
And you meant 2011-05, I think.
I think it's 2010. All this is on maternity leave, so I'm not entirely sure, but I think
5 is the order.
Okay.
that was the order. Okay, sorry about that.
Thank you.
Hearing.
Yeah, based on the hearings of 2010.
Yeah, I think maybe my phrasing of things might have confused things more. I agree that our perspective is that all of the portions of the order 2011-0005 that weren't voided essentially act as a non-precedential decision where the board is not going to cite to them and say, we did this already, so it's done, but you could just copy and paste and put them in a new order if you so choose. What our concern would be from the prosecution team standpoint is that legal theories that would apply exactly the same to landowners as they did to Woods Irrigation Company's potential rights not be rehashed or re-argued absent additional evidence or facts. So that's our one concern. And then also that issues regarding Woods Irrigation Company's rights not be rehashed. Certainly the issue of any threatened unauthorized diversion and a cease and desist order that may issue to Woods Irrigation Company as the diverter and deliverer of water to the landowners is completely up in the air if any evidence is presented that distinguishes the record from how it existed when we were just talking about Woods. But our concern is that issues specifically addressing Woods Irrigation Company's rights and issues or legal theories that apply the same to the landowners as they do to Woods not be rehashed, because that would be a waste of resources. That's our perspective on that. We're definitely not opposed to the board getting all the evidence that's pertinent and reaching all the conclusions that are appropriate based on that evidence, but we don't want to be blind to the fact that a lot of evidence was already put on, and the board already did a lot of thinking about that. It went up to the Court of Appeal on many of those arguments, and yes, a new order may want to reference the Young decision, but I think that what was written and discussed already largely doesn't need to be duplicated other than based on new evidence. That's our perspective. So I think I was maybe unclear as to using the words order and what should be changed, what should be readopted.
Vice Chair, if I may, I do have to address this concept of rehashing. I actually think that that's exactly what due process requires, and let me explain why. If a party is not given an opportunity to cross-examine a witness at the time that they put forth their evidence, then the decision maker is not given the opportunity to understand the value of that evidence or the relevance of that evidence based on the cross-examination. So, if you have evidence that you have relied on for the purposes of drafting the prior order that was not subject to cross-examination and scrutiny by the landowners at the time that it was put on, you very well may view that evidence differently after that cross-examination has occurred. And so the rehashing of some of these other pieces of evidence or arguments is exactly what due process requires must occur. And so I'll leave it at that. I think we may have a fundamental difference of opinion here. But
On this point, sorry to interrupt, Ms.
Yeah.
Paletta, but did you believe that the notice of hearing and what we've circulated for consideration meets that that aspect of due process in terms of allowing the landowners this opportunity to cross-examine witnesses that had testified prior in the hearing?
I do believe that allowing the witnesses or the landowners to cross-examine helps. The problem is that if the only purpose of that is to see if we change your prior decision, that's where I think we run into trouble. I do understand Mr. Rose's concern about resources, and that's why we fully support working on stipulations, factual and legal, so we can really streamline and just get to the meat of where we think we need the cross-examination and new evidence to come in.
Okay.
But I'm very concerned about the need for rehashing certain things, because that's exactly what due process requires.
Okay. You know, I think I get that point, you know, in terms of we're trying to be expeditious, but at the same time, I think we've raised concerns in certain ways of how we've phrased things in the documents you've reviewed. For instance, you talked about flip-flopping in an order of, you know, the questioning. And to me, I view these as both valid and not really having a hierarchy, but I understand the logic of asking one question and then following on. And I also understand the concern about, you know, starting from the order and then doing minor modifications as opposed to a good faith effort, respecting due process, to be open to reevaluating in the context of such issues as rebuttal, cross-examination, etc. I believe it's our intent to approach this with an open mind and not narrowly amend a prior order. And I think if it's helpful, you know, for us to state on the record that that is our intent, you know, and so I'm very comfortable with committing to a new order that doesn't amend a prior order, if that helps. And also that, yes, evidence should be considered, and then the issue of issuing an order as opposed to modifying an existing order. So I think we can achieve our goals of an expeditious hearing, you know, and consistent with how we've noticed it in terms of the opportunity for additional witnesses, landowners to ask questions, provide additional evidence, and still benefit from all the work, the investment that's been put into this effort. So I hope that's useful to state.
Valerie?
Yeah, if I may, I think for me, the question of how much of the record or the order that you keep is directly related to scope. I mean, if we're going to toss everything out, then we're going to have to open the scope up. If we want to keep this really, really narrow and you're just looking at a few issues, then you might be able to keep more of the order. But that's, I really think that's the fundamental question we're all talking about here, right? Is how much we're going to keep, how much we're going to throw away, and the scope that needs to match that. So, I mean, if you want to keep most of the order, the scope is going to be, by definition, I think, narrower. If you're willing to re-look at everything, and if due process requires, you know, cross-examination of previous witnesses, and that, by definition, might change the previous evidence, and then you're looking at really keeping very little, or at least not maybe keeping, but really coming to the same determination is what I would say. I mean, then you're going to be re-looking at all the evidence and coming to a really brand new decision. I think those are just fundamental issues, but to me, those two go hand in hand. And then just one other issue on kind of related to that I think we're going to have to talk about, and whether it's through stipulation or other mechanisms. But if it's on a more narrow scope and we're just looking at landowner information, the relationship between the woods right and the landowner's rights, and whether they can equal, you know, no ceiling, or whether there's a subtraction from one and a ceiling of another. I don't know if I'm saying that correctly, but you know, that's a major fundamental issue. If the hearing is going to be narrow, that's going to be something that we all need to talk about quite seriously and critically early on.
Well, I think you've touched on some of the details that we'll be discussing in the hearing, you know, in terms of what is the appropriate approach to calculations, you know, and we're not going to settle that now, but because, you know, just as an engineer, you know, the calculations have a big effect on the decision, and before you go through the details of doing that and determining whether certain things are additive or duplicative, going methodically through the calculation, we can't, you know, all due respect, we can't, to your earlier point about, well, I don't know what the order is going to look like, you know, if we're basing it on calculations and evidence and reconsidering evidence, we don't know what the order is going to look like. You know, we need to give that process its respect and a certain amount of patience. You know, yes, we want to be expeditious, but we will not shortcut, you know, when it comes to these careful calculations.
Eileen?
One additional thought that maybe we'll get to a little bit later today, related to all of this, is what is the participation going to be of the parties? And so, depending on the scope, if it's very narrow and as it currently framed, are the existing parties really limited essentially to rebuttal? If it's going to be something broader than that, are the existing parties entitled to put on cases in chief? And we certainly think that we should have the opportunity to do that, given the importance of the issues that have been raised, that there may be more data to consider. We are not at all suggesting, and I want it to be clear, that there be a complete start over. We think that the existing record needs to be given appropriate recognition, but it's likely that it will need to be supplemented, and we advocate that every existing party have the opportunity to do so, so that you can make the best decision possible.
Yes, no, we recognize you've made that point in your briefs. I think we're going to get to it later in our determination. Right. But you know, I think before moving on to that issue, which is coming up, you know, we should talk more and talk about, you know, ruling on the scope of the hearing.
It is 10:25. Oh, they're matching. That never happens. It's 10:25. We'll take a 5-minute break and come back at 10:30, and then we will rule on the first request which you made, and then move on to the clarifying the scoping. Thank you.
Thank you.
decision issued on it. A couple of them had hearings. No decision. Dunkel settled. David was given which is actually something that, you know,
but I mean, do you have historic, pre-14 all the way through data? Okay, that's what I, that's what my. No, I'm not speaking to that.
You meant that we find historic data.
Yeah, because they said things that were missing before. Yeah, the data that we tend to distribute, that's what we would have available. So I just wanted to make sure because it's suggested. It'll be interesting. No, the pre-hearing notice. Priority, that's priority and season, my understanding is, but I think it is the priority. I think that's what I'm wondering, is the scope for color in the water. Quote, color.
I apologize. I had no idea we had a 5-minute walk to get to our room. So I messed up, but now I know. So first, we are prepared to rule on the request from San Luis Delta Mendota Water Authority, Modesto Irrigation District, the state contractors, and Westlands Water District to request a change of scope that was described, that you described earlier. We have agreed that we will deny the motion to expand the scope. We do want very much to keep this focused on woods and woods customers. And we recognize that there are some other issues, there may be overlapping players, but for this particular proceeding, we want to stay focused on woods. On the second matter, where we had a long discussion and actually very helpful discussion of scope, we will be putting into a letter a kind of rework of what we laid out initially, and we'll send this out to you after we finish the rest of the day. And as I say, it was extremely helpful. So we're still, kind of thinking through how we will do that. But it will be it'll be focused on woods and woods customers then and now, and we'll see how we can make it as clear as possible. Because I hear you, Valerie. I mean, keeping it fuzzy doesn't really help. But I don't think anyone wants to do that. So you know, threading this needle is going to be very interesting. So you'll get a letter with